Good evening. This is John Milburn for LAWS12062 Alternative Dispute Resolution. This is week 1 of term 2, 2019. We have a good number of people online, so welcome everyone. Thank you very much for joining us for the live session. And for those of you watching as a recorded session, please consider joining us Monday evening, 7 o'clock during term for the live sessions. We always enjoy the opportunity to engage in some discussions. And remember, of course, that we meet during the term only, so during vacation breaks, I won't have the live session. If you're joining us in the live session, usual rules apply. I invite you to mute your microphone unless you're asking a question. It's not to suggest that I don't want you to ask questions, quite the opposite. Please unmute your microphone, ask questions at any stage. I mentioned just before starting to record that I recognise some names. So for those of you that I've worked with in the past, nice to see you again. And for those of you that I haven't worked with previously, welcome on board, and we'll enjoy the next 12 weeks. ADR is both interesting and extremely important, at least in my view. I may be biased because I've been practicing in ADR since, I guess, the mid-80s, and I've been a lawyer since the early 80s. I've started studying law straight from school, embarrassingly, and I have studied, taught, practiced or made decisions around law pretty much every day since 1977. So I have a lot of background, and what we're dealing with tonight is, in my view, perhaps the most creative area of law that you can practice in, because there aren't that many rules. What there is an option for you during the course of studying this unit to consider a number of alternatives as to how to go about a particular task. And in practice, you have that same opportunity. So many people studying ADR won't be lawyers. Many ADR practitioners aren't lawyers, but as you might expect, given this is part of an LLB degree in law, the focus on alternative dispute resolution that we will discuss and that I'll teach will be to do with a legal background. So the focus is on those people that wish to engage in ADR as practitioners, or at least understand how practitioners go about their work, with a particular emphasis on practicing law and the legal aspects then of ADR practice. But it is very inventive, and there are many different ways that we can proceed. Let's have a look at the Moodle website first. I'm sure that by second year, you're all very familiar with Moodle website. And what I want to do is just share my screen, and hopefully now, and please correct me if I'm wrong, you can see the Moodle page. Is that what you see? Good, okay. All right, so we're all familiar with Moodle page. Just a few things on the left-hand side top, unit profile, unit context, and the various forums. Unit profile to provide you with details about the textbooks. The textbooks are firstly, Principles of Dispute Resolution by Spencer, and secondly, the supplementary text, Alternative Dispute Resolution by Tanya Sorden. They're both very good textbooks. My philosophy is look at what you need to achieve and work backwards from there. So it will stand out to you on the Moodle page, in the top left-hand corner, that the first assessment is due on the 12th of September, 11:45 p.m. Please don't be late, because there will be a 5% penalty for late submission. And there is a cut-off. I won't accept work after the 21st of September. You can apply for an extension, but of course, the fact that you are aware of the actual assessment work that needs to be undertaken and the date, and that I've given you a warning not to be late, makes it particularly difficult to obtain an extension if something happens, for example, in the last few days before the assessment is due, because the obvious response to that will be, you've had all term to know about this assessment, So the last few days really made no difference to whether or not you could submit your work on time or if you were well organised. So please keep that in mind, not to be too tough. The second thing is the take-home exam, released at 6:30 p.m. on the 10th of October, due on the 11th of October at 11:45 p.m. So this is, if you like, the replacement to the invigilated examination. And I suspect that many of you have already undertaken examinations for the university using take-home papers. I know there are problems for those of you that have internet connections that aren't the best, and I appreciate that. So I'm going to ask you to carefully think about how you can ensure that you are both available and ready to submit your work by the due date, given that you'll only have it released to you about 29 hours before it's due. So, of course, book out your diary, make your arrangements at work and with family, friends that you need to do, and make sure that you've got some access to the internet so that you can undertake your work. In the past, with the take-home paper for ADR, and I've taken this unit for quite a few years now, I've undertaken different methodologies for and travel for some. I know that, Mary. I appreciate that. Different methodologies for the take-home paper. I'll just explain that. Therefore, if you look at take-home papers that I've set over the past few years, they won't necessarily be an excellent guide to what you might expect in 2019. But I'll give you a hint. You see, in some of the take-home papers that I set years ago, I would allow much more than 29 hours. I think my record was allowing 4 days for a take-home paper. But the task on that occasion was for you to go out into the field, as it were, and to contact ADR practitioners, real life, and to undertake a process that was as much as realistic as we could make it. I then went a completely different way, and as I recall, set a paper that was very short in duration. And you can understand, therefore, that the type of tasks that I set you in those circumstances were completely different. This is, for want of a better term, a mid-range timetable, 29 hours. You won't need the full 29 hours, but if you allow 3 or 4 hours, that should be plenty. Some people will give more time to it, and that's fine. When it comes to discussing the take-home paper, I'm fairly liberal in my approach. In other words, I'm happy for you to collaborate to some degree, but not collude. So if you've worked with me in the past, you'll probably have a good idea reasonable idea of what I say is collaboration and what is collusion. But I want you to do some research on that now, so that when you're discussing matters or purporting to discuss matters with your colleagues in relation to the paper, and indeed the first assignment or any work that you do during this unit, you have a reasonable idea of what's permissible and what's not. As I recall, on one occasion, one very industrious student hosted a Zoom meeting to coincide with the release of the take-home paper. And that was open to all in the unit. And in fact, I jumped on board with their permission just to say hello. So that's an option that you might like to explore. But what you can't do is write papers for each other. You've got to be careful to keep the discussions of a general nature and to genuinely exchange ideas in an open manner. So I'll make that disclosure at the start. I'm more liberal than you may find with other unit coordinators. So please don't assume that my approach to what is collusion or collaboration matches that which you might expect from colleagues. I'm at the liberal end of the spectrum. All good? Part of the reason that I adopt that approach is that I want you to adopt a collaborative process in studying ADR. I want you to discuss matters with each other. These are not in any way group assignments that I'm setting, but they are assignments where I expect you to at least engage, certainly in the first one, with your colleagues, and I think that's a good thing. Just a word now, well, I'll just go back to the Moodle site and just highlight a few other important aspects. All right, so on the front page, the Moodle page, you'll see the assessment regime. That's where you upload your assessment work. The first assessment is a mediation or conciliation, and you will record the session and you'll upload the link in a Word document. And in that Word document, you'll provide a short description of whether you're undertaking a mediation or a conciliation, and you'll provide me with some brief background to the factual circumstances that has led to the dispute. Now, of course, this is entirely fictional. And the idea of the first assessment, which is due on the 12th of September, is that you work with each other to some degree. The word limit is only 300 words. And as you can see, I'm clicking on the assessment piece now. I suspect that you've all had a look at this. And I can see that people have already started to exchange ideas in the forum. So hopefully you can see the assessment there. Due 12 September 2019. Your task is practically orientated. This is a practical unit. And apart from telling me something very briefly about the mediation or the conciliation, your key task is to act in the role of a mediator or conciliator. Now, where it looks a little bit like a group assignment, but it's not a group assignment, is that I invite you to work with your colleagues who will act as role-playing participants for the assessment. So when I'm looking at marking your work, you'll be the mediator or the conciliator. You'll ideally have two of your colleagues who are in some form of dispute with each other. They're not being marked for their performance in any way, but hopefully by working in conjunction with some colleagues, at least you'll have an idea of what the task is all about, and they can perhaps assist you by playing the role in an appropriate manner. As you're recording this in one session, one sitting, you'll, as you're having this one sitting, you'll upload to YouTube. You'll record it and upload to YouTube. If you keep it private, please make sure that when I come to view the session, I can open the session. It is, I must confess, a little annoying if I have to write to you to say, I can't get in to view the session. Many people leave it as public, and I think that's a good thing. Spread the word, spread the good news so that others can see what you're doing. That might be a hint that you could probably see what others have done in the past, if you think about it, because I have run this assessment previously. Now, when I say one session, I don't mean that the very first time you attempt a mediation or conciliation in this taped atmosphere is the one that you must submit. You can have 20 practice runs, if you like, before you finally submit your work. But when you do submit your work, it must be in a session that is continuous. So I can see exactly how you've gone about your process in full. You can undertake the work in a live face-to-face setting, or you can undertake the work via Zoom. In other words, you can record the session entirely as we're doing now and upload that session. And it's a way of the future that we have mediations and conciliations being undertaken through audiovisual means, and I do that in practice as well. So as I mentioned, you can consult with peers at your discretion, but your work must be original, and don't collude. So don't act together to cheat or plagiarize or engage in academic misconduct. The word limit is 300 words. That's really not particularly significant. The main thing is the session itself. In fact, really entirely the session is what I'm looking for. And you'll see the rubric as part of the assessment piece. and some information about how to record the session. If you're having difficulty in the technical side of things, please ask a question or have a look at the excellent material that one of your colleagues prepared, which I've uploaded, and there's some other material as well. So on the front page, you'll see the various forums, and you'll see the ADR Group Assessment Forum, where there is a contribution by people already. So thank you very much for that. And the idea is that you will tell me your groups. So here's the Word document that I maintain. I've just flashed it up onto the screen now. I will reproduce this and upload it to Moodle progressively. So as at today, I have no groups, but you'll see that I've got a few prompts here. If I see a couple of names, say on the second line, and without a third name, I'll put vacancy. So that's a free-for-all. Anyone can grab that vacancy, just let us know. But as a courtesy, let your colleagues know that you've taken it. And then on the very right, you'll see status confirmed or draft. So sometimes in reading the material, I might pick up that this looks like a group has been formed, but it hasn't been confirmed. I'll mark it down as draft. When you have got your group of 3, please send me an email, one of you, but CC your colleagues in so they know it's been sent, and tell me about the group, and I'll record it at that stage. I hope that makes some sense. All right. Are there any questions then about the first assessment piece? When it's due, what are the technical requirements, and what it is that I'm, in basic terms, seeking from you? Any questions?
Yes, John. What
Yes,
I
Mary?
want to know is it up to us to invent a dispute scenario, and does all 3 group members have to agree and do the same thing, or can we each do our own individual disputes but act the parts for the other people?
Excellent questions. So to answer your first question, yes, it's up to you to determine the dispute scenario. So you might have a particular interest in family law or commercial building disputes, international law, guardianship, contract law, whatever it might be. So think about a dispute. Sometimes if you're really stuck for an idea, what you can do is look at a case that interests you, and think that looks like an interesting factual scenario. I'll just make my dispute around that factual scenario. So you come up with the dispute, and as part of the 300 words, you give me a brief overview of what it is. This is a neighbourhood dispute between such and such and such and such, and they're arguing over whatever. So come up with that idea. And the second thing is that it need not be the same dispute for each of the team members. In fact, I'd be surprised if it is. So you come up with your own personalised dispute, and you pitch it to your teammates and say, look, here's what I propose to do. It's a dispute between a couple. The dispute relates to parenting. Can one of you play the father, one play the mother? And here are the broad facts. But usually people run with it themselves. So when you're conducting the mediation, it's good if you don't know exactly what they're going to say, because it will give you a chance to showcase your skills. So Mary, to answer your question, you come up with the idea, and I expect that everyone will have their own different ideas. Thank you. Any other questions? Okay. So when I say it's a good idea not to have too many details, I can give you an idea of what I don't want to see, and that is I don't want to see a fully scripted mediation, word for word, as if it's the script for a play. It's not like that. This is freestyle work. This is something where you need to be spontaneous and think on the run. But you've got the safety net of knowing if you really don't like what you did, you can just say, I've stopped recording, I'm not submitting that work. Let's start again. Try that a few times in your colleagues may become a little tired of it. So it's best if you can get it on the first go, but you understand what I mean. So have some basic parameters, but don't script it heavily. Okay, and you might come to some agreement about the extent to which the parties are in disagreement. Sometimes the mediation works very well if the parties really give the impression they don't like each other, and as the mediator or conciliator, you need to work a little harder, perhaps, than might be the case otherwise. So that's probably a good thing. All good? Okay. Now, in terms of your general approach to this unit and law generally, we've got a question here. I'm trying to join a group but can't find the link. So the link is on the front page of Moodle. Go to the LAWS12062 ADR Assessment 1 groups, and you'll find a discussion. So the idea is that you don't have to use that. You can phone each other if you like, or send separate emails or Facebook. But if you do, thank you, Leonie, if you do come up with a group, the idea is that you send me an email. Okay. So in terms of philosophy for law, if you go right back to Introduction to Law, I know that I say to the students at that stage, the quote at page 267 of The New Lawyer, thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. Please keep that philosophy in mind as you're conducting or completing this unit or dealing with any issues. It's a good philosophy because to be successful in your studies and law, I think you need to adopt that approach. So keep it calm and work the problem, as it were. This week we're dealing with an introduction to ADR. Over the next 12 weeks we have different topics. I'm not going to stick strictly to the format, but I do ask you to read ahead. The textbook, Spencer, it's really quite short and it's pretty easy reading. So there's no reason why you can't read well ahead. And I encourage you to do that so that you've got more options available to you as you consider the work that you need to do. Start thinking about your assessment now, and in terms of maybe having a separate document for each of the assessment. As an idea comes to you, you can include that in there. And again, if you need some help with the technical side of things, please let us know. Right. Just in terms of the text, an online version is available if you wish. There are a number of very good textbooks on mediation, negotiation, and other skills around ADR. So if you need to broaden your reading, some of the other good ones are Lawrence Boulay and Naja Alexander on mediation skills and techniques is the name of the text. And of course there's Alternative Dispute Resolution by Tanya Sorden, which is the supplementary. It's a much more detailed text. And there's Mediation Principles, Process and Practice by Boulay. That's a LexisNexis commentary as well. Each week, I will invite you to look at the review questions. I'd ask you to post your response in Moodle, and you'll find those problems at the end of each week in the material, and we'll discuss those from time to time. Sorry, if you're presenting any work, make sure that you present it in a format that is professional. Have a look at my sample document, which I think you'll find in the assessment material guide, and do write persuasively. Remember, of course, there's not necessarily a right or wrong answer. And when you're completing your work, make sure that you follow protocol in terms of referencing and the 4th edition of the Australian Guide to Legal Citations. All right, no questions All good? Chapter 1 was an interesting read. Thank you for that contribution, Paris. So when it comes to ADR, just be aware of the history. This is a new subject in some ways. I know that we have legislation that's of some age, but in terms of it being mainstream, ADR really only reached that status in the 80s. And I was very quick to get involved in ADR because I like the concept. So it's now very popular, it's very broad, and it's become popular in a short period. I guess like e-law and environmental law, it's one of those burgeoning areas of practice. And what you'll find is that as you undertake the work in this subject, this unit, and in practice, it's a matter of trying to blend the ADR process and options in with the way in which you conduct litigation typically. And indeed, quite a lot of the ADR processes don't relate to litigation, but that's where it started in the 80s. So you need to adopt a different mindset in ADR practice to the mindset adopted by litigation lawyers. You see, in litigation, typically, the way it was run in the 70s and 80s is that it was like parallel tracks on a railway line, in that one party started down one track, the other close by, but never touching, going down the other track all towards the court, and never really going across to meet each other, if that makes sense. So the idea of ADR is either at the start or right at the end or on the way through to bridge the gap so that you have an opportunity to engage in some meaningful dialogue and discussions with a view to resolving matters. When you're dealing with ADR practice, remember that it is in many ways based in and around litigation. So can someone tell me an important litigation-based document that might have a significant bearing on ADR practice within a litigation sphere? I know that's a very cryptic question. It's my way of just stopping talking for a while. What document related to, I'll give you a hint, civil practice, might be relevant when considering ADR? Residential Tenancies Act, yes, that's a piece of legislation, yep. Australian Solicitors Conduct Rules, oh, I like that one, Gemma, that's good. Any other takers? Some document that you might think has a bearing. Civil procedures, Peter, yes. What civil UCPR? Jack got it. Jack got the one I was actually looking for. Thank you. Any other litigation-based documents that may have a bearing on ADR practice? How about practice directions? Has anyone actually looked at practice directions? If you do my units, I'll keep pushing you towards them because they're important in practice. Family law? Yes, for evidence and proof. Yep. So what I'm suggesting is that the text is a little part of what you need to read, but you need to read much more widely and think laterally. So most definitely look at the UCPR and look at practice directions. If you are, Jade Barnett, it's a great resource. If you're undertaking work in mediation or conciliation, you need to be aware of those statute-based pieces of documents. All right, so ADR can involve many different processes, but essentially what you're looking to do is prevent a dispute or resolve a dispute. The two can be very closely aligned, but need not be. And either way, there are certain skills that you need to adopt in a practical sense as an ADR practitioner. So again, I'm just going to see if I can get you to give me some quick answers. Just off the top of your head, what do you think some of the important skills might be for an ADR practitioner to be effective. Impartiality, or like that one, communication, patience, professionalism, or you are quick. Excellent responses. Anything else? Did I miss them in that flurry? Knowledge, listening, very good. Negotiation skills, yep. In order to assist parties to resolve a dispute, you need to know the dispute, but you need to have, am I allowed to say the third eye, that you can look beyond that and you can see behind what people are saying in a way that gives you a proper understanding. You do need to have good communication skills, and it pays to be likable as an ADR practitioner, or at least attempt to be likable as an ADR practitioner. You see, you can understand that when you're in a mediation or conciliation session and you're attempting to encourage the parties to resolve, Gary's raised a good issue, you need to put the parties at ease. That's right. You need to gain their trust, don't you? And you need to be something of a sponge for emotion. No bias is really important, says Mary. And Gemma says it's hugely important to put personal opinions aside when it comes to controversial issues and people. That's absolutely correct. And you've got to be conscious of that and test yourself in relation to it. Professor Ashman from the Queensland Civil and Administrative Tribunal says of a good mediator that at the end of the process, you've become the party's new best friend. That's not a bad way of approaching it. So do they trust you? Do they accept what you're saying? Now, of course, you can't be the friends to everyone in terms of getting an outcome or encouraging an outcome that works for everyone in all circumstances. So when you're embarking on an ADR process as the facilitator, as the mediator, as the practitioner, you might want to keep something like this as a stock statement that you make to the participants. And that is, I encourage you to come to an agreement. It may not be an agreement that you think you need. It may not be the agreement that you want. But if you both walk away a little dissatisfied, then perhaps it's about right. So try and work on people's expectations of what they can achieve through the process so that you may end up with a better result. Now, when we talk about listening, we really mean a particular type of listening. Can anyone guess the word that I'm searching for that precedes the word listening? Active. Very good, Jack. Thank you. Active listening is really important. What that means is that you're being proactive and you're not just listening to the words, but you're doing something beyond that. And Peter says it would be extraordinarily difficult task to change from adversarial position to mediation. Yeah, sometimes lawyers don't always make the best ADR practitioners, but they can do. They can do. Sometimes it's useful to have a lawyer as the ADR practitioner, particularly in a conciliation, where you want a greater degree of direction in the process, and you do want the ADR practitioner to provide some feedback and possibly even an opinion. So you'll need to develop for yourself a list of the advantages and disadvantages of ADR and advantages and disadvantages of particular types of ADR. And in this unit, I think the number of ADR processes we consider is 14. I'm talking about mediation and conciliation tonight as if they're the only two. They're not. So there's a whole bunch of them. So as a working document, please ensure that you understand the benefits, the disadvantages of each one of the ADR processes that we deal with. And you'll probably say, how do we know what these ADR processes is? Well, I'll tell you in a moment. Generally, people say ADR is advantageous because it's quick, it's efficient, and it's a good way of resolving issues. But can anyone think of any other general benefits of ADR beyond the speed and the thrift aspects? Costs reduced, absolutely. Cost. Informality, yes, because people do like something that's informal. Ease of access, says Gemma, thank you. It can help things remain civil, says Jack. I like that response. All right. Creates trust, very good, Taylor. So the reduce the burden on the courts, yep. Statistics show a good success rate, yes, Mary. And Paris says sometimes it can help children talk about things that they won't with parents. That's an interesting point. I like that response. So there are a whole range of reasons why you might think that ADR is an appropriate process. One of the important things I like, and one thing that I do, in fact, actually say to people at the commencement of an ADR process, is that this is an opportunity for you to take and continue to have control of your own dispute, to own your dispute, rather than hand it over to lawyers and courts to make the dispute, to make the resolution for you. See, owning the dispute is an important thing for people. It's got to be theirs. They've got to have that sense of ownership. And a good ADR practitioner will allow them to do that. Sometimes people don't want it. Sometimes people say, I want a third party to make the decision. But of course, you're really limiting the options if you do that, and you're relinquishing control of something that is very important to you. So I'm not sure that that's always a wise choice to do. Now, when it comes to planning ADR, you have options to determine the process and work with the people in deciding how that process should work. So I've mentioned that there are a whole range of ADR processes, but even within a subset of those, there are different ways that you can go about the task. Again, mediation. It's all very well to say mediation, but there are different forms of mediation, conceptually and practically. So conceptually, mediations might be facilitative or evaluative or quite directive. In terms of the practice and the physical process, they might be face-to-face, they might be telephone, audio-visual, or they might be shuttle. Does anyone know what I mean by shuttle mediation? Okay. The media, yes. Any thoughts? And you can unmute your microphone on this if you want. Shuttle mediation, go between rooms, says Leonie. Yes, that's it. Different venues, Peter. Yes, that's possible too.
I was going to say, speak to individual parties first before you think about bringing them together.
That's a good idea. And what I do in practice, I mean, and there's a whole range of, and different practitioners do things differently, but I usually try to have some form of informal intake process before the mediation session, like not on the day, a week before or several days before. So I engage with the parties one-on-one, either face-to-face or by telephone or by a Zoom session like this. So that, and that is confidential between us, that process. But what it means is that perhaps for half an hour, for example, I can try to build some sort of rapport with the individual and gauge what might be the best type of process. It's quite remarkable that when I go through that process, very often parties will say, there's no way I'm going to sit in the room with him or her while we discuss this dispute. And I might get that from both parties. But towards the end of the half-hour session, I will invariably invite the parties to consider the benefits of engaging face-to-face part of it is they can better determine the outcome, and it does provide an opportunity for the parties to communicate effectively. And usually what you might think will be a shuttle mediation turns into a face-to-face mediation, which is, in my experience, generally more effective. Now, I know that some of you from backgrounds in statutory ADR processes will say, oh no, the way we do it at work is we have shuttle mediations, and they're very good and they're very effective. I probably tend to disagree with that approach because I'm a real fan of the face-to-face. But everyone has a different approach, and what I'm saying isn't necessarily right, it's just my view. Catherine says, seems very similar to other lawyer types roles. Isn't the end goal the same? Persuasion, if trying to persuade the parties to compromise, get along. Yeah, to some degree that's right. Law is very much about persuasion, and ADR is a good way to showcase your abilities in that regard. Now, I mentioned that ADR is relatively new, but if I could take a moment to quote one Abraham Lincoln, who said, discourage litigation, persuade your neighbours to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man, woman, he forgot to say that. There will be business enough down the track. So when you're being an ADR practitioner, what you need to do is consider, in conjunction with the participants, options for, if you like, the peaceful and effective resolution of their conflict. It means adopting a certain mindset, and it can result in a very rewarding career. You will see that there was legislation at an early stage in Australia in terms of arbitration, and that's a form of ADR. The Commonwealth Parliament gave power to the Commonwealth to make laws in relation to conciliation and arbitration for the prevention and settlement of industrial disputes beyond the limits of any one state. So even though I'm saying this is a new area of practice, clearly it's not. I've just referred to Abraham Lincoln and the Commonwealth Constitution as having some practice associated with ADR. But it's commonly thought that the current version of ADR was commenced by an American litigation lawyer called Eric Green. And this was in the States where there was a large commercial dispute, and the parties agreed to run a mini trial. They agreed on the rules, they exchanged materials for a couple of days, and management met for half an hour before reaching a settlement, saving thousands and thousands of dollars and time. That was very inventive because it was a form of mediation, or ADR rather, that was not often used or indeed ever used. So that was a mini trial. So there are different versions, and you can therefore be very creative in the way that you go about undertaking your work. I will ask you to do some more homework this week. So what have I asked you to do for homework this week? Read your text and read ahead. What else have I asked you to do for homework this week? Can anyone remind me?
Answer the questions and put them
Yes.
up.
Answer the weekly questions. Thank you, Mary. That's 2. More than that, Emma got it. Pros and cons of ADR, and not just ADR broadly, but each one of the ADR subsets, thinking about the benefits and disadvantages of each. Thank you, Paris. What other homework have I given you? Leonie says, find a group, which means getting onto Moodle, exchanging ideas. You might even have your group of 3 and send me an email. So that's part of your homework as well. So I've given you lots of homework, even though we've just been chatting. I'm going to give you some more homework, and that is I want you to start looking around websites to get an idea of who does mediation ADR work. I'll give you a few examples to think about. One is the Institute of Arbitrators and Mediators, referred to in Spencer on page 9. Community justice centres also do ADR work in a neighbourhood context. The Queensland Civil and Administrative Tribunal is another. The Land Court has some excellent ADR processes. The Planning and Environment Court is another one. The Family Law, Federal Circuit Court, Family Law, is another which has a heavy emphasis on ADR practice. There are some commercial organisations, the Australian Commercial Dispute Centre and the National Alternative Dispute Resolution Advisory Council, NADRAC. Now, you'll hear NADRAC and you'll read about NADRAC a lot. It doesn't exist anymore, but its very short existence was highly influential in terms of ADR practice. So you will need to consider NADRAC, even though it doesn't exist any longer as a specialised organisation. I then want you to think about 8 things, and we'll cover these in the next few weeks. These are what I've called applied skills in ADR, and we'll work around some slides in a presentation that I made. So number 1 is I want you to understand the alternative dispute resolution options. Number 2, I want you to be able to explain the ADR options and provide advice to your clients about the options. Number 3, understand the role of participants in ADR proceedings. That is, the actual parties in dispute. What is their role? Number 4, I want you to understand the basic ADR procedures. We'll concentrate on mediation and conciliation. Number 5, I want you to develop some skills about preparing for ADR process. Number 6, skills involved in participating in an ADR process, the various players. Then number 7, specific skills, and number 8, specialty ADR processes, especially mediation and conciliation. So there's some more homework for you. I want you to have those topics laid out in a document so that as you read material, come across cases, find websites, whatever, that help you with each of those points, you've got somewhere to put them into and catalogue. Now, they're just my 8 topics. You can come up with your own and develop subsets of those if you wish. But the point is that I want you to start working on a working document that works for you, that you can use in a practical sense. So that if you're, for example, number 2 was explaining the ADR options and providing advice to your clients, it dovetails in with the pros and cons of ADR. So one document might fit neatly into the second. Do you understand what I mean? So it's a matter of thinking about ADR from a practical sense, from a practice perspective. I don't like using this word, holistic, but I will. It probably doesn't sit very comfortably with information about law, but I do think that when you're looking at a legal problem, you need to consider it as an advisor holistically. The mindset traditionally has been, we go to court. The mindset now is going to court's one option, but there are a range of other options. So another part of your preparation is for you to prepare a document that outlines the various options that are available to you that are ADR type based. Now, they're not just the 14 that I'm going to talk about in a minute. They can be much broader than that and a different emphasis. So, for example, option number 1 might be, if you're dealing with a client with a problem, walk away and forget it. Number 2 might be approach the person that you're dealing with and invite them to sit down with a cup of tea or have a beer. Number 3 might be to exchange emails or do something else. So looking at it very broadly, so these are not ADR processes themselves. They're not options for ADR, but they're options for people to consider that are based around this concept of a resolution. When you're looking at your studies, think about, as a particular emphasis, ADR in the courts. So I've mentioned a few different courts and tribunals in that regard. Now, I've mentioned that there are 14 processes that we're going to deal with today. Can anyone tell me where they think there might be a list of those 14 processes? Has anyone come across them? No? All right. Have a look at page 3 of your text. You'll see a graph. And they're not numbered, but there's 14 of them. So as practitioners, you need to select from a wide range of alternative dispute resolution options. Here, David Spencer has selected 14. There are more than 14, but these are the ones that we'll work around. And if you like, they are at the top right-hand corner, the most informal or consensual or non-interventionalists options, down to the bottom left, which are the formal, non-consensual interventionalist options. So number 1 is the most informal option, that is negotiation. Number 14 is arbitration. So when I mentioned the options that you might consider to your client, number 1 was walking away from the dispute. It's not mentioned, it's not one of the 14. Number 2, sitting down and having a cup of tea, was kind of an example of negotiation. But exchanging emails was also an example of negotiation. So the most court-like, of course, out of all of these is arbitration. And that's a very formal, very court-like process. But still, of course, has its place. And we'll talk about the commercial arbitration legislation, which is nationally based, as an important guide to that. But for the most part, you can expect our discussions, particularly in the first 8 weeks leading up to the first assessment, will be around the ones in the middle, which are number 6, conciliation, and number 7, mediation. So you need to pay particular attention to those. So what do you need to do? And this is the last bit of homework for you for tonight, is you need to understand the process. So start to put together a list of, to identify the process in mediation and the process in conciliation. They're, unsurprisingly, the answer is they're very similar, but there are some key differences, of course. So start to develop a list of what is involved in the process for each of those things. And given that your first task is to be the mediator or the conciliator, you'll need to understand the process because you have to guide the process. And I'll be looking for you to do so. I'll give you a hint. Apart from intake, which I'm not really expecting you to undertake as part of this assessment, the first thing you need to do is an opening statement. I've given you some hints already tonight as to the sort of things that you might include in an opening statement. And when I asked you for information about what's involved in mediation, there was a whole range of different answers: impartiality, fairness, I forget what they were, but there were a whole range of different options that people came out. So please remember to start the process of preparing an opening statement and do that this week. So as you're reading through the material, read actively and think, is that the sort of thing that a good mediator or conciliator would tell the parties during their opening statement, explaining the mediation process? So Paris has kindly given a good list. Thank you, Paris. If anyone didn't get it, homework. Find a group. Create a list of a document with the benefits and disadvantages. Read ahead. Look at websites. Who does ADR in the textbook and elsewhere? Understand the procedures. Develop skills for ADR process. Skills needed. Types of ADR on page 3. And then work on the process of mediation, process of conciliation. Thank you. I think there might have even been a few more than that. But that's very good. Thank you. All right. So by next week, you should have been well advanced in all of those things. And please let me know as we progress. If you have any questions, please ask through the Q&A. I'm looking now, and we don't have a single question. So if you go on Q&A, you'll be the first one to ask a question. In terms of the forum for the first assessment, as I mentioned earlier, we do have a few people already that are having a chat and looking to get some groups organised. So that's growing as we speak, so thank you. All right, before I wrap it up, are there any questions, comments?
Yes,
All
John.
good? Yes, Mary?
So far, and I may be wrong, but my perception in what I've read in the text seems to be mainly New South Wales based. And given this is a Queensland course, is that what you want us to concentrate on, the legislation in Queensland and the different ADR, you know, availabilities here? And I mean,
Yep.
I know there's Commonwealth Acts, like, you know, in the family law court and arbitration and stuff like that, but is it Queensland that you really want us to concentrate on, being Queensland course? Or?
Yeah, so but you're absolutely right. Spencer is New South Wales based, so it is a big emphasis on New South Wales law. The default position is, yes, if it's state based, I would prefer to see it Queensland, but when it comes to doing your assessment work, I'm always very keen for students to make it relevant for them. So nothing from overseas, but any of the Queensland based. So if you're undertaking this unit and you live in and practice in Tasmania, then please refer to the Tasmanian law. I'll have to look it up to make sure that I'm happy with it. So you don't have to go with Queensland, but that is the preferred option for me. That's the default. Thanks, Mary. Any questions, comments? All good? All right. Thank you very much for joining me this evening. We look forward to the next 12 weeks and we'll see you next week. All the best. Bye then.
Bye, John.